require the submission of sexual assault kits to the crime labs and will help prevent Wisconsin from ever having another backlog. What it sets up is two options for survivors, and the bill itself is very focused on empowering survivors of sexual assault. If a survivor chooses to report to law enforcement, the sexual assault nurse examiner needs to contact the law enforcement agency within 24 hours to let them know the kit had been received. Then law enforcement needs to collect the kit within 3 days, and 14 days after that, the kit then needs to be sent to the state crime labs for processing. The law also provides for retention of those kits so that critical evidence remains saved and stored in case there needs to be further testing in the future. And it allows DOJ to collect data. Again, that law goes into effect July 1st. In addition to that law, there's also legislation passed creating a sexual assault kit tracking system. We announced the launch of that system recently. The Madison Police Department, led by Chief Barnes, is one of the agencies that piloted that program, and it is now up and running statewide. Again, this was done with survivors of sexual assault in mind and empowering survivors. This system allows a survivor to go online using a barcode to find out where their kit is in the testing process and to see exactly where it is, and if they want to contact law enforcement or get further information, they can do that. So this is really transformative for our response to sexual assault in Wisconsin. We are taking steps on multiple fronts to make sure that we never have a backlog of untested sexual assault kits in Wisconsin again. And by doing that, we are doing two critical things, because when sexual assault kits are tested, in some cases, the perpetrator who's responsible for a sexual assault is identified. A critical law enforcement lead can result from that. So by testing every kit, we are doing everything we can to get justice for survivors of sexual assault, and we're also making our communities safer by working to hold people who've committed a dangerous crime accountable. So the message that I hope survivors of sexual assault across Wisconsin are seeing is that in Wisconsin we stand with you, and we are going to continue working to strengthen our response to sexual assault. So with that, let me turn it over to Dane County Sheriff Kelvin Barrett.
Good morning. Wisconsin Act 116 aims at helping survivors of sexual assault. The unthinkable experience creates trauma for individuals that can last a lifetime. I would like to thank Governor Tony Evers, Attorney General Josh Kaul, all elected officials, community members, community leaders, and community advocates for their effort and energy in making this act a reality. The goal of law enforcement during a sexual assault investigation is to minimize additional trauma and provide respect and dignity to the victim or the survivor. In a criminal justice system where we commonly place the focus on the offender in the investigation, Wisconsin Act 116 is an historical step towards shifting the paradigm to our victims and our survivors. Wisconsin Act 116 further states that with the permission of the victim, it requires law enforcement agencies to take possession of a sexual assault kit from a healthcare provider within 72 hours of receiving the notification, as well as send the kit to the state crime laboratory within 14 days of taking possession, all with the permission of the victim. If at any point prior to sending it to the state crime lab, the victim chooses not to have the kit analyzed, the law enforcement agency must still send it to the state crime lab for storage up to 10 years. Our role in an investigation is to ensure safety, minimize additional trauma, be there for support, and ensure the victim has a choice in this process. The passing of Wisconsin Act 116 allows these priorities to be at the forefront of each and every one of our sexual assault investigations moving forward. Thank you for your time, and it is my honor to announce the next speaker, Senator Melissa Agard.
Thanks, Sheriff. So, over 6,000 unsubmitted kits were here in the state of Wisconsin, not too many years ago. These are unsolved cases. These are victims who deserve closure. These are suspects who must be held accountable. We know that in Wisconsin, victims and survivors of sexual assault have already gone through the unimaginable, and their path forward to justice and to healing should never be obstructed or delayed. We know that for too long, sexual assault kits, each one of those kits representing a human being, a victim, an individual, someone who is loved, someone who deserves justice. Their reality, the unimaginable reality in Wisconsin for too long was on shelves, leaving them and the investigators who want to hold those suspects accountable for the critical next steps. And that is not okay. That's not the Wisconsin way. And I applaud the work that has been done by Attorney General Josh Kaul in helping this bill cross the finish line and be signed into law by Governor Evers as Act 116. So today, we're here to celebrate the fact that this goes into effect on Friday. And for a long time, many of us didn't think that we would actually be here to see this happen, because we had so many different stops and starts. But we do, when we commit ourselves, we do cross these finish lines, and we can reach to the point we can celebrate lifting up the people of our state. This bill is a game changer for victims' rights. We are empowering survivors in Wisconsin to have a voice in what will happen next with their very personal story, their very personal rape kit, this evidence, rather than having it be left on the dark or in a shelf or somewhere where we're not even sure. And this is long overdue. This is a policy change that will provide deliverable support and deliverable protections for survivors of sexual violence in Wisconsin. And we can now ensure that the systems are in place to prevent this from ever happening again in our state. And we're going to be able to take a very needed step to uphold the dignity of survivors, to uphold survivors' choice, and to uphold the rights to fair and just processes for these survivors, protecting not only those who are choosing not to report a rape at the time of the assault, but also to allow them to later change their mind, and at the same time, holding accountable those who have committed these heinous crimes, these unimaginable crimes in our state. And while I know that there is not one piece of legislation, or two, as we've mentioned today, that is ever going to erase the trauma of sexual violence, we need to know that there are ways that we can remove these barriers to justice. And that's what we're doing here today. Over the years of serving in the legislature, I have heard from countless victims and survivors of sexual violence and sexual assault, from their family members, their loved ones, and from those who have dedicated their careers to supporting these folks. And I carry these stories with me. And I have promised them that I am never going to stop working tirelessly on their behalf to build a better system. And I know that even after today, we have more work that we need to be doing. And I look forward to being able to work with all these folks. So today, while we're celebrating these important steps that we have taken to create a more just path forward, one that honors the dignity of survivors of sexual violence in Wisconsin, one that supports survivors of sexual violence in Wisconsin, I also must acknowledge that we have this work to do, to prevent and to address sexual violence and to support survivors in Wisconsin. So clearly, the message here, even in a government that feels really broken, we can come together. We do come together. We do the hard work. We convene, we deliberate, we debate, and we cooperate. And we've delivered. We've delivered justice. We've delivered solutions to Wisconsinites on some of the most pressing issues. And I call on my colleagues to keep this work up. And I want to thank a strong bipartisan group of legislators over a couple of sessions that have come together, as well as Attorney General Kaul and former Attorney General Schimmel, advocates, and especially the survivors who have shared their stories, on behalf of the people who haven't been able to do that. Because that is how we got here, and that's how we continue moving Wisconsin forward. This and the sexual assault kit tracking system are huge steps in our state. And Josh and his folks at the Department of Justice are diligent and they're compassionate and they lift up the people of our state to ensure that we have true justice, that we have true safety, and that everyone is on the line here to make sure that survivors in Wisconsin are being supported by their leadership, and that is to be applauded during these very difficult times. So let's celebrate this important work and also realize that we have more work to do. I am honored to introduce Madison Chief of Police, Barnes.
Good morning, everyone. My name is Chief Sean Barnes. Early in my career as a police officer, I had an opportunity to be a detective. And I worked in a unit at that time that was called Special Victims Unit. My unit investigated sexual assaults of juveniles. What we found is that in order to successfully prosecute these cases, we need the successful examination of sexual assault kits. I'm so proud today that our state has taken a very monumental step in ensuring that the successful prosecution of these cases will take place not only in a thorough manner, but also more importantly in a timely manner. Reporting a sexual assault is certainly a sensitive crime. It takes bravery, and it is a very hard thing to do. More importantly, it takes courage. We in the law enforcement and criminal justice profession must also have the same courage it takes to report, to successfully prosecute, and to examine all information and all evidence in a case. For years, sexual assault survivors in many states were left in the dark and forced to deal with the increasing number of sexual assault kits. This new tracking tool that the Madison Police Department was able to pilot for 6 months and help to develop gives victims more rights, which is something that we fully support in the Madison Police Department. We would like to thank Attorney General Josh Kaul and all of our legislators and leaders who made this possible. This system is a large step forward for sexual assault survivors. It empowers them by giving them the ability to learn more about the status of their cases. We call this transparency in the Madison Police Department. The Madison Police Department was proud to be a part of the pilot program and offer suggestions to the Department of Justice on sexual assault kit tracking mechanisms and processing. Our lawmakers understood the need for these changes and updates in legislation around sexual assaults. We remain committed to working with our local legislators on other ways to show support for victims of crime. This is great. This is a great first step, but there are other things that we can do to show support to victims of sexual assaults, and we remain committed to doing that in the Madison Police Department. Once again, I want to thank Attorney General Josh Kaul for taking this very important step, and all of the legislators here in the state of Wisconsin. It is my pleasure now to introduce Ms. Susan Allen Lee, who is a Forensic Nurse Examiner Program Coordinator at Unity Point Health, Merida.
So my name is Susan Allen Lee, and I'm the coordinator of the Forensic Nurse Examiner Program at Unity Point Health, Merida here in Madison. We used to be called the SANE program, or the Sexual Assault Nurse Examiner Program, but we've opened up the victims that we care for to not only sexual assault, but also domestic violence and strangulation. So now we go by Forensic Nurse Examiners. We see patients of all genders and all ages. We meet our patients where they are and give them the space and knowledge to make the best choices to care for their bodies and minds after an assault. One of the options our patients have is collection of potential DNA evidence from their bodies, also known as a rape kit. While our team does our very best to reduce trauma during an exam, having a forensic exam can be a difficult experience to navigate for patients. Our patients put a lot of trust in us to allow for swabs of their intimate body parts on one of the worst days of their lives. It would be much easier for a patient to only worry about their own mental and physical health during this time and not spend their limited energy allowing someone to swab their body. But many choose to go through this process for the sake of justice. Our patients emphasize they want evidence collected to prevent someone else from being assaulted by the same person. Patients who are reporting the assault to police expect their kit will be tested in a timely manner, something that hasn't always happened. What happens to the swabs in that kit is extremely important to survivors of sexual assault. Wisconsin Act 116 codifies the handling and testing of kits. It outlines the timely submission and testing of kits, and, most importantly in my opinion, it allows the victim to follow the process by monitoring the location of the kit. This puts power back in the hands of survivors to hold the justice system accountable for responsible treatment of the evidence taken from their bodies. This means avoidance of future backlogs, and it means more thorough sexual assault investigations. Act 116 is the state of Wisconsin telling each survivor they deserve to be heard, and their choice to test an evidence kit will be honored. The Forensic Nurse Examiner program at Meritor was part of the pilot process for the Wisconsin track kit system. At first, it seemed like a lot of extra work to put on our team at a very strenuous time for anyone in healthcare. But once we started explaining it to our patients and entering kits into the system, we found it was not complicated and it wasn't time-consuming. The small amount of effort it takes on our part is well worth what it gives to our patients. Our patient response has been overwhelmingly positive. The kit tracking process gives patients the option to track their kits, but does not require it, so there's no additional burden for them. If a patient is too overwhelmed to log into the track kit website, it's okay. Forensic nurses, law enforcement, and the crime lab will still ensure the kit gets to the appropriate place. While working with our patients, it's part of our duty as forensic nurse examiners to explain options for evidence collection. Survivors in Wisconsin have the option not to have a kit collected, have a kit collected and given to law enforcement immediately, or for those over 18, they have the option to have evidence collected and sent to the crime lab for storage without reporting to police. The crime lab will store the evidence for up to 10 years, allowing the victim time to make the right decision for themselves without losing the vital DNA evidence on their bodies. This last option, what we call an undecided kit, is one of the ways Wisconsin honors crime victims and meets them where they are without rushing. For those who choose not to report but still have evidence collected, they can log into TrackKit and be reassured their evidence is still there in the crime lab, available if they decide they want to make a report. Since I started as a forensic nurse examiner in 2014, I've observed Wisconsin taking many steps toward treating sexual assault victims with the dignity and respect they deserve. Act 116 is another large step in that direction. And I will hand it back over to Attorney General Kaul.
Great. Well, thank you again to everybody who joined us here today. With that, I'm happy to open it up for questions, but I'd like to request that we start with on-topic questions. I'm happy to take off-topic questions afterwards, but let's start with on-topic.
Along those lines, Attorney General, what changes to the DOJ's infrastructure is necessary to be able to store and test these kits within the time frame that aligns with this new law? And if somebody is not yet willing, a victim is not yet willing to report their assault to law enforcement, will state labs still test the kits right away to have that information and that analysis aid, or will the kits themselves be stored and that evidence preserved?
Yeah, so first, we currently are storing some kits when a survivor reports or a sexual assault is collected and a survivor does not want to report to law enforcement. Right now, in practice, those are being submitted to the state crime labs. What this will do is put into statute that practice, so it's now a required practice. So, you know, we at some point may need to expand our storage space so that we can accommodate additional kits. But we expect to be able to do that without much impact. In terms of the impact on law enforcement agencies, our hope is that this won't add any additional workload because law enforcement agencies around the state are submitting evidence to the crime lab fairly regularly. Regardless, what it does is it ensures that part of that submission to the crime lab will be sexual assault kits if there are kits to submit. In terms of turning the kits around and testing them, the more resources we get for our state crime lab for DNA testing, the faster we can test those kits. So I hope that we will continue to see the legislature supporting the crime lab and providing the resources it needs. There was one other part to your question, and I apologize.
If somebody's not yet willing to report this to law enforcement, will the state crime lab go ahead and test regardless?
So if the person doesn't want to report to law enforcement, it's stored at the crime lab, but it's not tested unless the person who provided the report wants the kit to be tested. And that's in part because the National System for DNA, CODIS, has certain requirements for DNA information to be uploaded into the system. And if a survivor doesn't want their information to be uploaded in the system, then we're not going to test it. But if they do decide to have it tested, then it's tested.
That said, you have an undecided kid sitting in the crime lab for 10 years while the perpetrator is out sexually assaulting more women. You could have stopped him, in the first year. So what are you accomplishing by that? I mean, you know you're trying to respect the survivor, but you're also putting other women in danger for another decade, or maybe you never catch this person.
Yeah, this is a choice that a lot of input from advocates for survivors and others who are involved in investigating cases put a lot of thought into, because the concern you raise is a concern with not testing the kits. Where we have come down and where the prior Attorney General came down is that, first of all, sexual assault is a massively underreported crime right now. And the more that we can do to make clear to survivors that we stand with them and that the process is going to be one that empowers survivors, the more that I think we're going to see those reporting rates increase and the more sexual assaults we're going to end up solving. Secondly, testing evidence, but without having the support of the survivor in the process, from a criminal justice standpoint, isn't going to get you very far in an investigation, because without the survivor wanting to move forward with the process, you're not going to get a prosecution that's successful in those cases. And what we really don't want to do is re-traumatize survivors of sexual assault by putting them in a position where they lose control of the process and instead somebody else is driving that process.
But now you could develop a profile of an unsub, now you can't.
That's true if somebody doesn't report to law enforcement as well. And it's our judgment that we're going to have more people reporting to law enforcement and more profiles developed with a policy that empowers survivors rather than one that requires them to go through a process they might not support.
How common is it that a survivor does not, or chooses not to report not to report, but not to proceed through the identification or the testing?
Yeah, we can get you the exact statistics. It's the vast majority of cases people do report to law enforcement, but there is a percentage where people don't report, or at least they don't want to report initially. And so, like I said, we can get you the exact breakdown of the data. In most cases, people report. When they don't, though, one of the reasons that having that process is so important is we don't want somebody to decide that they're not going to report at the time and then not have a sexual assault kit collected. We would rather have the person come in, have the kit collected, and then if they decide in a month or 6 months or a year that they want to move forward with the reporting process, when they're not in the midst of a traumatic situation, having to make a hugely consequential decision, that empowering survivors in that way, again, will lead to more cases being effectively investigated and pursued.
Is there a risk to the kit just sitting in storage for X number of years?
All else being equal, you'd want to test the kit as soon as you can. That being said, our crime lab has expertise in how to protect evidence and ensure that it remains testable. And so in some cases, evidence is stored for even longer than the period that is stored at the crime labs.
Aside from allowing survivors to track their kits to the tracking service, what sort of assurances are there to make sure that local law enforcement actually sends the kits to the state crime labs?
Yeah, well, first of all, there is now state law that goes into effect on Friday, and I won't speak for the sheriff and the police chief behind me usually, but I feel confident saying that they go out of their way to make sure that their departments do everything they can to comply with the law, and I know that the same thing is true for law enforcement agencies around the state. Secondly, there is the kit tracking system, which not only allows a survivor or somebody else involved in the process to go in and see what's happening with the kits, but it also allows us to take a systematic look at what's happening with kits and to analyze whether the process is being followed. And then we also have authority through this legislation for the Department of Justice to collect data regarding sexual assault kits. So that provides us another check to make sure that the process is happening the way it's supposed to.
So would there be any kind of like regular DOJ check with local law enforcement with some of those kits to make sure that they're fulfilling that timeline requirement?
Yeah, so we just launched the kit tracking system, and one of the things we're going to do is assess how to use that system most effectively to make sure that there's a review being provided and that kits are moving. We'll probably do a lot more data collection and analysis beyond making sure that compliance with requirements happens. But those processes are going to be developed, and having that data is going to allow us to analyze things like making sure that agencies are following the rules, but also lots of other aspects of the cases that we're seeing.
You mentioned 6,000 was the backlog before. Is it gone now, or where do you stand?
Yeah, so that backlog looked at kits, and I believe the analysis went up through the beginning of 2016 or the end of 2015. So the kits were inventoried around the state. Where there were kits that hadn't been tested, they were identified. The process of reviewing those kits to determine which ones should be tested and then testing those kits has been completed. There were a little over 300 left to test when I took office, and we finished testing those 300. What we had not had, though, until this kit tracking system was launched, was any way to keep track of each kit around the state, and that's because they were stored in at hospitals, in evidence locker rooms. Now with the kit tracking system, we can show where each kit is in the state that's collected going forward, and we can use that to determine if there are any kits that need to be tested that haven't been.
So today, the Supreme Court ruled that Fred Green can stay on DNR board indefinitely.
Can we do?
I promise I'll answer it, but let me just see if,
Well, I was waiting for
Nobody was asking.
Great.
Yeah, we're gonna do that. I just want to let folks step aside.
great. All right. Thanks, Todd, sorry about that.
So any reaction to that ruling and the ramifications for apparently allowing, a minority party to keep or party that's not in power to keep their appointees in the executive branch?
Yeah, I believe Justice Dallett in her dissent referred to it as absurd, and I certainly share her view of the decision. We have witnessed over the last 3.5 years a significant breakdown in our democracy in Wisconsin. We saw it with the lame duck legislation that was passed at the end of 2018. We saw it with the gerrymandering decisions that were issued. We don't have a representative democracy in our state legislature right now. And now we're again seeing it with this Prane decision, because what this is doing is allowing a legislature which does not represent the people of Wisconsin to expand its authority and control an executive branch agency. I mean, think about this particular case. There's an appointee. Governor Evers has been in office now for almost 3.5 years. His term is almost complete. And the majority of people overseeing our Department of Natural Resources were appointed by Governor Walker, who Governor Evers beat at the polls in 2018. That's not how democracy works. The people made a decision in 2018, and today the Supreme Court said that decision doesn't matter. And we have consistently seen power taken away from the voters of Wisconsin and given to the legislature. And in this case, we now have an appointee who apparently can stay on this board as long as he chooses. I mean, think about that in a democracy. This is not a country where we have kings, but Dr. Prane apparently gets to choose how long he gets to stay there, regardless of what the people of Wisconsin say. This is yet another warning sign about the health of our democracy in Wisconsin. And on top of all that, it's going to be really bad for our natural resources in Wisconsin. Dr. Prane has shown a commitment to opposing policies that protect clean air and clean water in Wisconsin. So if you're on the side of more toxic sludge in our water, this is a win for you today. But if you want clean and safe drinking water for Wisconsinites, if you care about people in Wisconsin having the power over our government, it's yet another huge loss from our Supreme Court.
Josh, what is your advice to someone right now
who wants to seek an abortion. You yesterday said that you believe they're legal. We have anti-abortion groups who believe they're legal as of right now. We have a mixed bag of DAs, Milwaukee and Madison said they won't prosecute. We have Sheboygan DAs say they will. Are you just doing a wait and see approach with the lawsuit filed yesterday, or what do you tell people who are very confused?
Yeah, well, the answer is we're in a state of chaos right now because our legislature has refused to take any action to update the 19th century law that remains on the books. For the time being, the possibility that somebody could be prosecuted is still there. I mean, our suit will resolve that issue, but in the meantime, abortion providers like Planned Parenthood have stopped providing services. So the way that somebody would obtain a safe and legal abortion in Wisconsin isn't available right now. Now, what we all expect, I think, is that we're going to see a lot of people traveling out of the state of Wisconsin to Minnesota or to Illinois while we work to get these issues resolved. But I would ask, where is our legislature? This is a huge event in the state of Wisconsin. And I haven't seen any indication that they're going to come back and take action, but we need them to come back and address this major change to our laws. I mentioned yesterday, we've started getting questions from sexual assault nurse examiners about, for example, whether they can dispense emergency contraception, whether they can advise people to take it. We got a question about whether there's an exception in the law for cases of rape and incest. Unfortunately, that one, there is a clear answer under the old ban, which is that there is no exception for those cases. So we're going to move as quickly as we can through the courts, but having the legislature come into session and take action right now is key. And I hope that every Wisconsinite who's concerned about this issue contacts their legislators and demands that they come into session, because that's what ultimately is going to lead them to do something if they are going to do something. Do you want to add to that?
Well, we anticipated this. We all saw the leaked document that was out there, and Governor Evers called us into special session to address this. And this chaos has been caused by the majority party here in Wisconsin's legislature. And frankly, that is disgusting. There are people's lives on the line here. And this confusion is just part of their playbook, unfortunately. We need to take action now. Someone who becomes pregnant or became pregnant a couple of weeks ago is now in limbo. And we do, thank goodness, have people on the front lines who are setting up procedures and protocol for folks that are finding themselves in that situation, but it is requiring traveling to another state at this point. And we do have folks that are going to help people have access to safe legal abortions in other states. We do know that this is not going to prevent abortions from happening in Wisconsin. Historically, abortions continue to happen, even when they are illegal. And what we are going to see in Wisconsin is people losing their lives and becoming injured because of illegal abortions being performed here. So I stand by the work of Attorney General Kaul. I applaud the filing that he took steps to take yesterday, and also am ashamed that my Republican colleagues in the Senate took 13 seconds to gavel in and gavel out last week, despite the fact that we knew this was going to happen. We can come back. There's nothing that's preventing us from coming back into the Capitol building, knowing that this chaos exists in Wisconsin right now, and taking action to stand on the side of people who do need the freedom to make healthcare decisions for themselves.
Do either of you place any blame on Democrats of the past for not taking care of this and repealing the ban when they did have a majority? Obviously, Republicans are in the majority now, but there were times in the past that it could have happened.
Yeah, I wish they had repealed it in the past, and I know that there were, a few legislators who prevented it from being repealed. What I can tell you is that, I wasn't certainly serving in office, Senator Agard wasn't, and if they want to bring this to the floor today, I'm confident that you will see Democratic legislators across the board pass it. I mean, this is a problem we can solve in a couple hours. They just need to come into session and take this up. So I do wish that the law had been changed in the past, but the people who are here now weren't here then.
Going back to Prem real quick, what's your thoughts on the precedent this sets on other
appointees?
It's a terrible precedent. It's going to cause chaos because you're going to see appointees try to hold on indefinitely. This won't be limited to Fred Prain, and we're seeing it on other boards as well. And what it does is, again, is it ultimately is taking power away from the people of Wisconsin to choose the kinds of policies they want to have and giving it to appointees to hang on as long as they decide to. And so we've got decisions being made not based on the will of the voters, but based on the whims of these appointees. And that's not how our system should function.
The decision outlined, by case basis for removal by the governor. What are some of the things that might fall under that?
Yeah, he's subject to for-cause removal. And I should mention, I know there's been a lot of talk about people threatening to remove DAs recently. For cause is a high standard, and it's not something where you just disagree with somebody so you get to kick them out. There's got to be something much more serious than that. That's the basis for removal. And if there weren't, our entire system would break down because DAs are elected. Some of these appointees are meant to stay on beyond the term of the governor who appointed them. Now, Dr. Prain has stayed on way beyond even that, but it's a meaningful standard and doesn't mean that there aren't cases where it applies, but the idea, it doesn't leave the governor with nearly as much discretion as he should have because he's the one who was elected by the people.
Going back to the abortion lawsuit, I assume you're expecting it to end up in front of the state Supreme Court. How do you like your chances there?
I think that we are right on the law here. We've identified some areas where there's a clear conflict between the current sort of more recent set of laws and the prior set of laws. As one example, there's an exception for cases to protect the health of the mother under more recent law. There's no such exception under the old law. So I think that we are right on the law. I'm obviously aware of the makeup of the state Supreme Court. And we've lost some cases there, but we've also won some really significant cases there. And what I would say is we're going to make our best argument and we'll see how things shake out.
The Sheboygan County DA, which of course is in one of the counties where there would be an abortion clinic, if Planned Parenthood moves forward with, I know they're not scheduling any, but there is a clinic in Sheboygan. The Sheboygan County DA has said he would enforce the abortion ban. Do you believe that Governor Evers should move to remove them?
This is back to this earlier question. We have policy disagreements. I disagree with him on that approach. But I don't think we should have a system where the governor can, whenever he or she disagrees with somebody like a DA, just removes them. We have elected DAs. And so just like Fred Prain shouldn't be overruling the will of the voters, the governor shouldn't be overruling the will of the voters if there's a policy disagreement. It's a different story if it's something that rises to that for-cause level. But in a case where there's just a policy disagreement, I don't think there's that authority.
So if the Sheboygan County DA were to go ahead and try and prosecute someone under that 1849 ban, are there any legal avenues you could take to challenge that prosecution, or would you take those avenues?
I can't speak to hypotheticals. I mean, it would depend a lot on the specifics of a case. Generally speaking, when DAs are handling prosecutions, our office is not directly involved in that point. I mean, I've been clear that we wouldn't in any way support those kinds of prosecutions, and including through resources, and we certainly wouldn't do that. But generally, those are the person charged and the DA are the ones involved in the court case, and that's who you'd normally see in that kind of case involved. Great. Thank you, everybody.